then this is a very common situation I've had with a number of my clients, and it just makes the hair on the back of my neck go up. But it's very common, I'm sure. Do you know what confidential information your employees are disclosing? The sales and marketing department of a company with a Twitter presence encourages all sales employees who are subject to confidentiality and non-compete agreements to create individual personal accounts to follow the company and to get customers to follow them as individuals as well. Now, again, the whole purpose of social media is to get exponential communications about the brand and the organization, and to have these connections with the people that we do business with. But, and again, it might not have been a bad idea, but they went about it the wrong way. They encouraged people to get personal Twitter accounts, not individual company Twitter accounts. They were personal Twitter accounts. And talk about taking away from your ability to enforce confidentiality and non-compete agreements. The minute that these people left the organization, they have their ready-made, customer list, and they have the ready-made ability to say, hey, I'm not there anymore, I'm here. So again, there's not anything wrong with having a plan and using social media, but doing it the right way, and I'm going to tell you how to do that. But before I do that, I want to talk to you about some of the cases that are out there right now. And they're from coast to coast. I have a California, I have a Pennsylvania, and I'm sure there's everything in between as well. But PhoneDog is a company that rates different cell phones and different cell phone plans. And that's certainly something that's very much on the internet, and they wanted to have a really big internet social media presence. So they hired this one individual to market the brand. They provided him with a Twitter account. He, over the period of 4 years, develops around 17,000 Twitter followers of him. He quits and brings the followers with him to a competing organization by just changing the Twitter name. And he had that account personally so that, again, he could easily do that. And ultimately, the company is claiming that there was economic interference, conversion, which is theft, and misappropriation of trade secrets, including the Twitter subscribers and the password to the Twitter account, and allowed the case to proceed. And again, there was a lot that the company could have done to prevent this from happening. Then there's Eagle versus Morgan, and this is in Pennsylvania. The company in question was a company that provided training to banks, and Eagle was an executive with the company. And over several years, she developed thousands of LinkedIn connections. She left the organization at some point, and she sued the company when it continued to use her LinkedIn account after her discharge. And it was pretty bad. They took off her picture, they took off her name, put her successor's picture and name on her LinkedIn account, and had all of her awards and all of her credentials and all of the content that had been generated while she was employed there. And last but not least, Third Circuit out of Delaware. There was a company president of a debt collection service. He sells his company, and as a result, he leaves, voluntarily resigns after the sale. He has a non-compete agreement, a non-solicitation agreement, and so forth. He forms this competing business, which was in and of itself in violation of his agreement, but he did worse than that. He updated his LinkedIn profile to reflect his new position in business and encouraged people to apply for employment, which again is not so bad. What he did that was really bad was the next bullet. He sent friend requests to all of his former employees at the company that he just sold and got lots of money for via Facebook, and asked them to review the LinkedIn solicitation for jobs, which, again, direct violation of his non-compete agreement. He did it in a public way. Of course, the company that he sold his company to found out about it, was very upset, and sued. And they actually got an injunction against the competing business as a result. Consider implementing confidentiality and other social media-related agreements. I have been very active in drafting agreements just with regard to people who engage in social media use on behalf of organizations. They're very specific. This account belongs to the company. This account shall only be linked to your work-related email. You shall not change passwords unless directed to do so. You shall forfeit any access to this account upon termination of employment. The passwords are confidential, proprietary information. That I pack in as much fact into these agreements that will help us be able to defend ourselves and even dismiss claims if and when somebody sues us, and certainly we can very easily go after people for their violation of these agreements. So if you don't already have agreements like that, you should consider putting them in place. They can be part of your confidentiality agreements. They can be part of your non-compete agreements, but they can just stand alone as well. But do something to prevent those cases that I gave you, the 3 in particular, where your former employees in particular are hurting your organization and taking away your goodwill and costing you hundreds of thousands of dollars to defend yourself or to prosecute a claim. And it doesn't have to be that way.